Yes, ready for dictation. 3, 2, 1, start. The Learned Counsel further submitted that accused Gurvinder Singh and Surinder Singh have been given benefit of doubt by the learned trial court on the same evidence which is the basis for convicting the appellants full stop. He therefore contended that, in view of this fact, the appellants were also entitled to be given the benefit of doubt and ought to have been acquitted full stop. Sri Kiranjit Singh, learned counsel appearing for the appellant Subhas and the appellant Amarjit Singh, who is also the writ petitioner in CRWP number 130 of 1995, reiterated the submissions made by Mr. Ghai and further submitted that, as per the case of the prosecution, Man Singh, who is the father of the deceased and is the real brother of convict Subhas, was present at the time of occurrence. Full stop. Mr. Kiranjit Singh submitted that said Man Singh, however, has not been examined by the prosecution with some ulterior motive and failure to examine him. Full stop. In support of this submission, he placed reliance on a judgment of the Supreme Court in Habib Muhammad versus State of Hyderabad 1954 within bracket 1 SCR 475 full stop para. He further submitted that the inquest reports exhibits PC and PF did not contain the names of all the accused, and it was mentioned therein that Subhas and his sons had attacked the deceased with their respective weapons. Full stop. Similarly, DD reports exhibits DX2 and DX3, which pertained to commencement and completion of the FIR, did not contain the names of the eyewitnesses or the weapons used by the accused, and it also did not contain the names of the accused and the injured. Full stop. He therefore contended that this contravened the provisions of section 154 of the Code of Criminal Procedure, and as such the uncorroborated testimony of the alleged eyewitnesses PW7 and PW8 could not be relied upon for convicting the appellants. Full stop. In support of his submissions, the learned counsel placed reliance on the following judgments. Full stop. Para. The learned counsel further submitted that there was unexplained delay in recording the FIR in this case. Full stop. He submitted that, as per the case of the prosecution, injured Harmohinder Singh had reached the hospital at about 10 pm on 21/2/1990, and in terms of the statement of Dr. G.S. Goyal, who examined him. Full stop. He also submitted that the evidence of the bank manager, who was examined as defense witness, clearly shows that the complainant, who was the real brother of the deceased, wanted to grab the amount lying in the bank account of his deceased brother, though as per law the widow of the deceased brother was entitled to have the amount. Full stop. It was therefore contended that the alleged eyewitnesses PW7 and PW8 could have murdered their deceased brother to grab the amount lying in their names in the bank. Full stop. In support of the averments made in the writ petition, the learned counsel for the petitioner submitted that the order dated 10th May 1994, by which the learned trial court had closed the defense of the petitioner, was illegal and was in violation of the principles of natural justice. Full stop. The learned counsel submitted that, in fact, operation of the aforesaid order dated 10th May 1994 had been stayed by a learned single judge of this court in criminal miscellaneous number 7254 of 1994. Full stop. The learned counsel further submitted that, though the learned sessions judge was informed about the contents of this order of the learned single judge at 3 p.m. on 10th May 1994 itself, but still the learned sessions judge pronounced the judgment on 11th May 1994 full stop. The learned council submitted that wide order dated 22nd March 1994. The learned sessions judge had rejected the applications filed by the petitioner under section 311 CRPC for recalling certain prosecution witnesses for further cross examination, and the case was adjourned to 27th April 1994 for defense evidence of the petitioner full stop. The learned counsel further submitted that on 27th April 1994 the petitioner, however, could not examine his defense, and on 27th April 1994 the learned sessions judge was informed that the petitioner had already challenged the order dismissing the application of the petitioner filed under section 311 CRPC in the High Court by way of revision petition, and said revision petition was fixed for hearing on 18th May 1994. Full stop. Over.